When people begin the divorce process, they often want to know what will happen with their finances and whether they can afford to get a divorce. This is an uncertain time because two people who have lived in one household now have to live in two separate places. It is usually more expensive to live separately than it is to live together. A spouse who has relied on the income of the other spouse might worry about how he or she is going to survive financially. The spouse who has supported the other spouse often worries about having to pay alimony and whether he or she is going to be able to survive financially. Alimony payments allow a spouse who has relied on the other spouse for financial support to live in a comparable lifestyle for some period of time. In order for alimony to be awarded by a court in North Carolina, one spouse must be a dependent spouse and the other spouse must be a supporting spouse. A dependent spouse is a spouse that relied on the other spouse's income during the time they were married and living together. If the dependent spouse had an affair, however, prior to or on the date that the couple separated, the court will not award alimony. If the supporting spouse had an affair prior to or on the date the couple separated, the court must award alimony to the dependent spouse. The question still remains for the court to decide the amount and duration of the support payments, though. As an attorney who has been practicing this type of law for many years, I can tell a client that they will probably receive or owe alimony. What is much more difficult for me to figure out is how much they will owe or receive. I gather financial information from both parties and look at monthly budgets to determine how much a spouse will need to support him or herself and to determine how much the other spouse has remaining after paying his or her bills. After this process, I usually have a better understanding of what a court might do, and I can better guide my client in negotiations with the other spouse. In North Carolina, there is no clear-cut guideline to help us determine how much alimony will be ordered. The court can order that alimony be paid for a specific amount of time, but it can be ordered indefinitely as well. In determining the amount and time alimony will be awarded, the court will consider all relevant factors, including marital misconduct of either spouse, the relative earning and earning capacity of each spouse, the ages and the physical, mental, emotional condition of the spouses, the amount and sources of income of each spouse. This includes earnings, dividends, and benefits such as medical, retirement, insurance, and Social Security, the length of the marriage, the contribution of one spouse to the education, training, or increased earning power of the other spouse, the extent to which the earning power, expenses, or financial obligations of a spouse will be affected by serving as the custodian of a minor child, the standard of living they had during the marriage, the education of each spouse, and the time it would take to become educated or trained in order for the spouse needing alimony to find a job to meet his or her reasonable economic needs, the assets and liabilities of the spouses and the debt each spouse has, including any legal obligation of support, the property brought to the marriage by either spouse, the contribution of a spouse as a homemaker, the relative needs of the spouses, the tax ramifications of the alimony award, any other factor relating to the economic circumstances of the parties that the court finds to be just and proper. The fact that income received by either party was previously considered by the court in determining the value of a marital or divisible asset in an equitable distribution of the parties' marital or divisible property should also be considered. Alimony is not a black and white issue because there are so many variables. If you have questions about what you might owe or what alimony you might receive in a divorce, contact Stallard and Bellof for a consultation.